Sorry, I've just been at the gym yesterday. Okay, so have we got everyone? We're just waiting for a couple of people. You're our camera woman. Okay, so we're moving on now. We've talked about just general dispute resolution and dispute resolution options. And now we're going to move on to the law in relation to children. So under the Family Law Act, what's the law relating to parenting arrangements for children, generally in the context of when their parents have separated? So parents have separated, they haven't been able to agree on what arrangements should take place for their children, that is, time children spend with each parent. What's the law and how do the courts use the law to make decisions about children? And it can be helpful for us just to sort of know a bit about this and know a bit about the background. Even though in mediation we're not actually, it's not a court process, we're not applying the law, we're helping people make their own decisions about the children. But it's particularly helpful because sometimes people have things in court, sometimes they've had legal advice. Also, there's lots of misconceptions about what the law is and misunderstanding, so it can help us to sort of understand what the law actually says to help people make sense of it. So we're going to look at the types of parenting issues courts can deal with, terminology and how it's changed over the years. That the overriding consideration for the court is this phrase, the best interests of the children are paramount. How the court works out what's in children's best interest, which is often a very difficult decision, and I'm glad I'm not a family court judge. Sometimes I'm not sure how they make these decisions. And actually I've got requirements of parenting plans and have a draft parenting plan. I don't think we'll probably get up to that today because we're going to deal with that in a later session. So what parenting issues can courts deal with? So basically, the time children will spend with their parents, the time they'll spend living in different parents' households, something called parental responsibility, which is about making major decisions for children, communication with their parents when they're not with them at that particular point in time. Also, when courts are making decisions about children, they can talk about how people will resolve their disputes in the future, and we can also put that in agreements that people can make. And basically at mediation, people can put anything in their agreement that they want to about what they've agreed in relation to their children. Now there's been some terminology changes, which are now, some of them are quite old, but some people and some of the media still refer to the old terms. So originally we had custody, access and guardianship. Custody being who the child lived with, access being the time they spent with the other parent, and guardianship being about decision making. And actually, you're reminding me I haven't given you my notes. Sorry, just seeing you looked at that, I thought, oh, I haven't handed this out.
Oh, that's good.
So I have got notes for this one. Maybe you can pass them around. It'll be easier because I'm so slow. concept where one parent would have custody and the other parent would have access. And then in 1995, the Family Law Act was changed, and the idea was to try and move away from that idea of children living with one parent and spending time with the other parent. And they brought in the concepts of residence, contact, and parental responsibility. That really didn't have much of an impact because generally children kept living after separation with one parent and spending time with the other parent. So in 2006 they brought in some new terminology, who the child lives with, who the child spends time and communicates with, and parental responsibility. But I think still the research shows us that predominantly children live most of their time with one parent. So the terminology we have now is lives with, spends time with, and parental responsibility. And when you're drafting agreements between people, they really have a choice now as to whether they say the child lives with one parent and spends time with the other parent, or the child lives with one parent some of the time and then lives with the other parent some of the time. That's really up to the parents. So firstly we'll talk about parental responsibility, because a lot of people out there in the community think parental responsibility is about time, but it's not. It's just about decision making. So the Family Law Act says that parental responsibility is all the duties, powers and responsibilities that parents have by law in relation to their children. Now if we have people where there's been no court orders, so I guess most people separate and they don't go to court, thankfully. So where there are no court orders, and also when we're not separated and parents are living together and don't care for their children, they each have parental responsibility for their children. So that's up until your child turns 18. And I guess as people who are parents would know, the older your child gets, the less say you get in terms of what they do, and you start out picking their clothes and their food and when they go to bed and what they watch, and then you end up
with nothing.
I've got 3 boys who are 21, 19 and 17, and I don't know if I have that much influence. I have a bit of influence, but it's certainly diminished, isn't it, in terms of
money. All the money,
all the responsibility.
It's certainly dissipated over time. That's right. They want me now when they want money, a lift, or food, to be fed. Okay, so when there are court orders though, we do draw a distinction between day-to-day sort of more mundane issues and what are called major long-term issues. So day-to-day decisions are, if a child's spending, so they're spending 1 week with one parent, 1 week with the other parent. When they're with one parent, the parent, particularly when they're young, has to work out what they'll eat, what they'll wear, what they'll do, what time they go to bed, what time, well maybe not time, maybe not what time they get up, but what time they go to bed, what they get to watch on television, or probably these days more relevant, what they watch on a screen. And actually my boys are playing this Pokemon Go thing, and 2 of them spent half the night till midnight going out catching Mewtwo and Zigbat and something. So what games they play. So day-to-day stuff, I guess just because of practical reasons, parents can't consult about everything, can they? And once they've separated, this often becomes a bit of an issue about what they do consult about and what they don't consult about. So what the law says is generally what they do day to day they don't consult about, but in a mediation you might have discussions about, so, you know, some of these things sometimes people do want to have discussions about, for example, food, particularly if there are certain food allergies or intolerances. So some of those things people do want to talk about, homework, but those sorts of things are day-to-day issues. Then the law talks about major long-term issues, and there is a requirement if there's a court order and if people have equal shared parental responsibility, which most people will have. Because generally, it's considered in not both parents, in the children's interest for both parents to have a say in their long-term decisions, although it's sometimes not that practical because they don't agree. But the theory is that if they have equal shared parental responsibility in a court order, they would consult with each other and try and come to a decision about major long-term issues. Major long-term issues, the main ones that come up are school, where they go to school, sometimes health, sometimes religion. I must admit it doesn't come up as much as the other things. Occasionally they have a dispute about the child's name, particularly surnames. Say if mum takes on a new partner's name and changes the child's name. There is a court case where parents had a dispute about a child's Christian name, so the court had to make a decision. And also what we might call relocation, or decisions where one parent wants to move and it will make it significantly more difficult for the other parent to spend time with the child or children. So if you're going to move 20 minutes down the road and it's not going to really affect the other parent, that's fine. But if you're going to move to another town, another city, another state, particularly another state or overseas, it's going to make it very much more difficult. And that is technically something that you should consult the other parent about if you've got equal shared parental responsibility. Now the Family Law Act actually says, just to make it clear, the decision to form a new relationship isn't a major long-term issue that you need to consult your ex-partner over. So, just to make it clear.
And neither is the child's communication with that new partner, is it? We get lots of people, like a new person, like the mother's calling because the father's got a new girlfriend and doesn't want the children to meet the new girlfriend, or vice versa.
Yeah, well that's certainly something you can talk about in a mediation. It's not technically a major long-term issue, but I guess those sorts of issues are sort of significant for parents, aren't they? About decisions such as, for example, when you'll introduce a new partner into a child's life. I've had mediations where we've talked about that, and for example, one couple agreed that we won't introduce new partners unless they're going to become serious relationships, for example. That's what, and a lot of people don't do that, but that's what some people might think is appropriate, because you don't want children to also sort of get attached to people and they don't hang around. So it's not a major long-term issue that you need to technically consult about, but if you're getting along okay, it might be something that you discuss and you make agreements about. Also about partners staying over the night and all that sort of stuff. Okay, so the ones that come up most in practice, and that's certainly one that's coming up for you, isn't it? That comes up for me in mediations. New partners can be very volatile issues. School comes up a lot. Also, the moving comes up a lot these days, particularly too because sometimes people do have to move for jobs now, because jobs are sometimes hard to get. So the moving does come up a lot.
And a lot of people want to move back to be close to family.
Yes.
So
Yeah.
they're separated. It's really common.
We get a lot of not major long-term issues, not major issues as well. Like doesn't see that the other parent doesn't need to consult.
Yes. Now they're not technically major long-term issues,
No.
but there might be things if both people will agree on talking about that at mediation. That stuff you can talk about, particularly about consistency.
Yeah,
Consistency, and you can have discussions about, well, what should be the same in both households and what could be different. And this depends on how well they get along.
Yeah.
Because sometimes, I'm sure everyone thinks, how on earth did these people get together in the first place? They're so different. They've got such different ideas about things. So it depends on to what extent they want to talk about this stuff. But they can certainly in mediation talk about routines, what they're allowed to do, what they're not allowed to do. They can really talk about anything, provided that both people will agree to talk about it. And that's the sort of stuff that can be quite hard for kids, can't it? About, I go to mum's and I'm allowed to do this, I go to dad's, I'm not allowed to do this, or I've got a bedtime in that house. And also the things kids, as they get older, they learn to really play off people against each other and all that sort of
Kids
stuff.
love it because they can go to one parent house and get away with so much.
They say,
more
I can
than
do
the
this
other
at mum's
parent.
house, and they go, oh, well,
Yeah.
okay, you can do that here, and they're not doing it at mum's house.
That's right. And there's generally the statistics are about 1 in 3 couples separate. So there's an awful lot of kids out there that are now moving between homes, and some people too, particularly say the legal aid clients I see, might not just have one ex-partner and one set of children. They might have 2, 3 ex-partners and 2, 3 sets of ex-children going all over the place, to the extent which when they're talking about it, like the other day, I couldn't keep track of all the people and the partners and the children, and you need to do little
So how the children do is beyond me, how they get trained.
Yeah, so there's an awful lot of children out there that are from separated families and moving between households, and I guess generally in children's sort of mediations we can really talk about anything as long as people agree. And sometimes it's sort of the underlying stuff that can really impact on how basic arrangements work.
Can I ask, how different, I understand that it's a case-by-case basis, but I've had a lot of clients where it's the stepfather or the stepmother, and so they're not biological, like, parents to the children, and obviously depending on how long the parents have been together, but in terms of parental responsibility, like, how does that change? Because until you go to court, you wouldn't know whether like if you have a child and then you have another relationship, you've been together for 8 years and then you break up, whether you, as the biological parent, whether...
So what do you mean in terms of parental responsibility? Who makes decisions, or?
Yeah, because it's not a biological parent.
Does a step parent have parental responsibility? Do you mean?
Yeah, and or would that need to be first determined by a court?
So do you mean, can a step parent apply to court?
No, like within the mediation process, so like we're learning all of this sort of stuff. Yeah, if it's a step parent, it's not a biological parent. I don't know how to put into words what I'm trying to say.
Yeah, well,
Like,
some of
do
the
they
scenarios I see are step parents can make applications to family courts if they've had a significant involvement in children's lives. So, for example, if they separate and they still want to see a child that because sometimes they've taken over, particularly sometimes the fathers have taken over the fathering role. So they can make an application in court. There's a section in the Family Law Act that says if you've had a significant involvement in a child's life, and you can participate in a mediation. I guess for mediation the other party has to agree. So they can make applications, they can participate in mediation. In terms of parental responsibility, when parents separate, it's the biological parents that technically have parental responsibility, and that's in relation to the major long-term issues, and they have to consult each other which often they don't do in practice anyway. But day to day, often step parents are involved in the day-to-day decisions and the discipline and all that stuff. So that's sort of a practical, just sort of a reality.
But do the step parents ever get granted at court hearings parental responsibility? They've been in the child's life from like when they're 12 months
I've had a
old
few
and
cases
they're now
where
like.
They could be.
It's been awarded
They could be.
full custody of children, usually because of child protection issues.
Yeah.
And
Yes.
so the 3 children that aren't theirs have gone to the step parent.
They can apply to court for parenting orders, so they can get orders about time children spend with them and parental responsibility. And they just really have to show a significant, and generally they wouldn't make an application. The other thing I've seen at mediation a couple of times is mothers that want stepfathers to continue to be involved with children after separation, and this just happens to be fathers in my mediations, but the fathers didn't want any continuing involvement with these particular, and they were all boys, so it was quite sad. In one mediation, the mother had brought a little note from the boy because he wanted to see the stepdad, and he actually had no relationship with his real dad, and the stepdad didn't want to have anything to do with him.
So can, in that case, can that stepfather be made to have
No.
Can't force an actual.
Why would you want to though?
No, but like to pay child support or anything like that.
Actually, I'd have to probably check about child support. Off the top of my head, I would think no to child support. But in terms of the family court, they actually don't even make biological parents see children if they don't want to, which can get quite frustrating when.
Sometimes it's better for them to have no relationship than a forced relationship.
Absolutely.
definitely.
Yeah.
No, definitely. No, I understand what everyone's saying. I just meant in terms of like, if they're not the biological parent, can they be forced to pay child support and the responsibilities?
Not
of
off the top of my head
biological
for child support. I'd probably have to check that though. There might be some circumstances where that might be possible, because generally it's biological parents that are responsible for child support, but definitely not for a spending time with the child if they don't want to. It's again something that you need to get their agreement to. So it can be quite sad, particularly for children that don't have their own biological father in their life, and they form an attachment with a step person, and then the step person, and say in some of the mediations too, the children are difficult type kids, they're challenging, and they're probably going to become even more challenging when they've got no father or stepdad wanting to have a relationship with them. So that can be sort of the flip side of that. Okay, so getting on to how courts make these decisions, which can sometimes be very difficult decisions because of all the emphasis now on helping parents make their own decisions about children. Sometimes the sorts of cases that get to court hearings are quite sort of nasty cases where sometimes both parents aren't particularly that appealing as parents. So, judges have got very difficult decisions sometimes between and people being in very high conflict. So they've got some sections in the Family Law Act that they have to work through. And that forms the structure of their decisions. So firstly, it's in the context of what are called these objects and principles, which are a long list of things, but some of them are, and this is repeated through the Family Law Act, ensuring, and this came in 2006, this emphasis on, generally it's in children's best interest to have a meaningful relationship with both parents if it's in their best interests, balanced against that they are safe and well cared for with their parents. Well cared for being sometimes a subjective term when we're looking at some of these families. Ensuring they receive adequate and proper parenting, ensuring people fulfill their duties, etc., etc. So it goes on, and there's quite a lot more objects and principles, sort of all parenthood type statements. then the overriding section is the child's best interests are paramount. So when judges are making an order, they have to regard the best interests of the child as paramount. Now that's all very well, but how do we work out what is in a child's best interests? Well, they have this list of what we call the best interest factors, and in 2006 they changed the list and they divided them up into the primary considerations and the additional considerations. The primary considerations being, again, the benefit to the child of having a meaningful relationship with both parents, balanced against being protected from harm. And not just physical, but also psychological harm. And abuse, neglect, or family violence. Now in 2011, because there's some problems with the way this section was interpreted, they added in, when the court is balancing these sections, they need to prioritise protection from harm. And that was because of a perception that the judges were really bending over backwards to give parents, sometimes in not particularly savoury circumstances, time with children, although actually it's supposed to be the other way around, children time with parents when maybe it wasn't going to be beneficial to them. And it's very hard for courts to actually cut off a child's relationship with a parent, so they're very reluctant to do so, even in circumstances where, you know, it's very sort of extreme circumstances. Sometimes, you know, very violent parents being extremely violent to the other parent, sometimes violent to children, children being exposed to very serious family violence in front of them, parents with psychiatric issues, all that type of stuff. Quite difficult issues.
Send those to you.
Yeah.
In this season, James contact service, they just go,
Ah!
you see those contacts.
Oh, I see. Now, in terms of when we say generally children should have a meaningful relationship, what is a meaningful relationship? Well, in the cases in the family courts, different judges sort of take different approaches, and a lot of the judges really assume that children will benefit from a meaningful relationship with both parents, which does generally make sense, but sometimes in the context of the type of parents that are in the court, sometimes maybe not that clear cut. But in this case, this is a female judge, Justice Brown, said it should be from the child's perspective as to whether it's a meaningful relationship. It should be important, significant and valuable to the child, and it's a qualitative adjective, not quantitative. Now what that means is it's not just about the amount of time, it's about the quality. And that's something that some of the changes to the law in 2006 about meaningful relationships, and also we'll get into it into a minute, a presumption of equal shared parental responsibility, which then triggers for the court a consideration of whether children should have equal time with each parent, really has meant that there's been, and this is quite a long time ago now, 2006, it's now 2016, so after the last 10 years, but say in 2006 or even before that, when all of these changes were being reported in the media, I was say in a mediation at Legal Aid, and a father came into the mediation and said, I've got a right to equal time. I know that's my right. So that's really how those changes impacted in terms of people's perceptions, and also about parental rights to time, that people talk a lot about now, my rights, and I want it to be fair, and I want my time rather than from children's perspectives. But actually the social science research really shows us, which makes sense, that from children's perspective, it's not actually about how much time they spend with the parent. Obviously, if they don't spend much time with the parent, they might not have as meaningful a relationship. But if it's not good time, if it's not positive time, it's not going to make any difference to them whether it's a lot of time or not very much. It's more about the quality of the time. And I guess you can think too, a parent might live in another state, but a kid has a good relationship with them, even though they can't get the face-to-face time a lot. But it's a positive relationship. The parent's interested in them. They know what they're up to. They're in regular contact, where it could be that they're spending week about with the parent, but the parent's not engaged and they're not, you know, not focused on them. It's about the parent's attitude to the child. So we said that the primary considerations are benefit of a meaningful relationship balanced against protection from harm. And then the other best interest factors, and there's a whole big long list. So some of them are any views expressed by children, but they're taken into account by the court in accordance with the child's maturity and level of understanding. So the older the child is, I guess the more weight possibly to their views, but also in the context of why they're holding those views. For example, a 15-year-old girl that's mum doesn't make her go to school and lets her stay home because she wants her to babysit her younger children. And daughter says, I really want to live with mum. Those views will be put in the context of, I want to live with mum because mum doesn't make me go to school. Now in Australia we don't generally have a practice of, for example, judges speaking to children. In other countries they do, like Germany and New Zealand. There's a couple of judges that have spoken to children directly, but generally we have children's views put before the court via a family report, but they don't have to express views, and some children don't like to take sides. So it's really depends on children, their age, and also their personalities. Some children are really concerned about parents and being fair, and might even offer to have half time with parents because they don't want one parent to be sad, or so there's all sorts of configurations that can happen. So views can be important. Nature of relationship between children, their parents and any other significant people. For example, step parents.
Can I ask you if, Donna, if family report, have there ever been disagreements about, not disagreements, but contested family report? If a report has been made around the family?
Yes.
Can a parent contest that?
Yes, so if you go to if you end up at a contested hearing, so you haven't reached an agreement, you end up at a final hearing, you can challenge the family report.
Okay.
So the way you do that is you put the family report writer in the witness box and they get cross-examined.
Okay.
And you can certainly challenge, and the sorts of things you might be bringing up are the time they spent with people, and maybe, you know, there might be some assumptions in the report too that are incorrect, for example, all that sort of stuff. So you can certainly challenge. So family reports can be really beneficial, but they can be really problematic if, say, and I guess I'm speaking from the background of being a lawyer, they can be really problematic if they're very negative against your client, because some judges do like to
Take that as the
really highly regard them.
That's right.
And not all clients can afford to go to contested hearings.
Right.
And also, say if you've got a client on legal aid, if they get a report that's against them, often their legal aid will be cut.
It's really prejudicial in a way, isn't it?
Oh, really?
Yes, legal aid doesn't have much money. It's Commonwealth government funded. Their funding's been cut back a lot over the many, many years I've been working with legal aid. And they don't like to generally, because often in cases there's a children for the lawyer for the children. They generally, if they will fund people to a family report stage, once it comes out, they will then look at cutting funding. And generally the report would then determine who gets their funding cut.
Would that be because they have more or less of a chance of ruling in their favour?
Yes, it's not always that cut and dry. Like the report might not be that cut and dried, but sometimes it's very cut and dried as to, and sometimes there might be a good reason for that too. One person may not have a great case and they might be wanting something very unreasonable that they want, but that isn't that great for their children. But other times, you know, there can be lots of different configurations. So other considerations, your involvement with children. This section replaced what used to be called the friendly parent section. So before the amendments in 2011, there was a section that was called the friendly parent section. That sort of was, you know, if you're a parent and you're not making your best effort to make sure that the child's spending time with the other parent, it could be taken against you. But that sort of was a double-edged sword. Like in some ways it's good to, just generally for people to encourage children to spend time with the other parent, but if that time isn't in their best interest, if the other parent is abusive, for example, then, so it was amended to this. Indigenous heritage, so there's a specific section there about considering Indigenous or Torres Strait Islander culture. Attitude of parents and responsibilities of parenthood. Family violence, particularly if there are any family violence orders. Now that means state protection order. So you take into account the nature of the order, the circumstances in which it was made, any evidence admitted, so that would only be if it goes to a contested hearing that there's actually evidence. Any findings by the court, so if it does go to a contested hearing, the court then does have to make a finding about whether family violence has occurred. Stability, whether it's preferable to make an order that makes it least likely that people will come back to court again. So when the court's making the decision, they have to work through those best interest factors one by one where they're relevant. You know, for example, if they're not Torres Strait Islander Indigenous heritage, they don't have to work through that section. But all the relevant ones the court has to work through and make a conclusion about each one. And then they have to go on to decide, this is where it gets more complicated, whether the presumption of equal shared parental responsibility applies. So this is where the court process gets quite, oh, sorry.
That's okay. Let's just pass it around.
There you are. No, actually, I probably should take one of them so I can remember what's in it. Thanks. So this just shows you, and it's quite complicated, and this is quite so misunderstood. So the court, we got down to section 60 CC, so that's the best interest factors. The next one is whether the presumption applies.
It's a lot less complicated than the one on the slides. So many different.
Oh yes. So what the court has to decide is it in the child's best interest for both parents to make major long-term decisions? If yes, they then have to go and consider whether equal time is appropriate. So they have to look at whether it's in the child's best interests and reasonably practicable for the parents to have equal shared time. Now, a lot of the time in court, they probably don't even get to this step, or they just dismiss it because there'll be a reason why equal time won't be appropriate, because generally people are in very high conflict when they go to court, and the research shows us that equal time works best when people can be cooperative co-parenters, which means they have to cooperate, and particularly if kids leave things behind in the other parent's house, they have to be cooperative to get things back, and they generally need to live closer together and all that sort of stuff. So there's actually a definition of reasonably practicable in the Family Law Act that talks about that sort of thing. So it'll say that the parents are able to communicate together and put their children's best interests at the forefront, that type of thing. If they decide it's not in the child's best interest and reasonably practical for half-time, they then have to consider what's called substantial and significant time, which comes from the research that says that children do better, if possible, if both their parents are involved in not just, say, a child living with one parent during the week and one parent on the weekend and having fun time with one parent. If it's possible that both parents be involved in stuff during the week, or time with the child during the week, time on the weekend, and time in school holidays and significant events. Now that's really the ideal. It's not always practical, particularly if people don't live close together. But the research was showing that it was better for children, particularly if both parents are involved in discipline, schooling, homework, that sort of stuff, if possible.
Can I ask a question? If you have like court orders in relation to children spending time with other parents, so on holidays for example, and the child is 16 or something and doesn't want to go, and it's considered that the parent should be encouraging the child to go. How do you prove that the parent is encouraging the
If they're 16, I think they're probably old enough to...
Is there a time when the court
There isn't
considers
actually a
that-
set age, but generally the court wouldn't make orders for a 16-year-old. So something that is an issue, I think, is, you know, if you...
So like past orders?
The trouble is the court
Because we
orders
have
stand
that-
there and
Yeah,
dance
we have that all the
till
time,
it's
like,
so
we
bad.
had court orders in place for a few
Yes.
years and the child's now at an age where the parent can't physically make the child go. And the other parent's like, but the other parent is not encouraging the child to go. And I was just wondering how you get around that, like how can you prove that another parent is encouraging? Because isn't it expected that a parent encourages the other child to follow the court orders?
Or is it your advice line, your information line? But something they should think about is, well, now that they're 16, it's a bit different in terms they might not want to spend blocks of time with you, but do you want to talk to them about how you can maintain your relationship in a different way? Because people that have got kids that age at home know that, you know, like,
spend time with their parents anyway.
my boys don't want to go anywhere with me, it's so embarrassing.
That's it. It's
Um,
not about you. it's
And it
about
might be about having a
them.
meal out, or it might be about going and watching them play their sport and, you know, doing stuff like that. So,
Well, have you had many, like, when there were much experience with parents, like, applying for contravention of court orders?
yes, I've actually
Children are
recently
like-
had a father that was ringing me for a mediation when he had a 17-year-old, and I actually said, and he was looking at going for contravention orders, and I said, I don't think that's a good idea. That could potentially alienate your son from you. What about, and I had all those suggestions I just said, and also about a child inclusive, another use child, he's 17. And the father actually wanted to go back, his lawyer had advised him to go back to court, which I think is the most damaging, because I can't imagine my boys, they would think that was so embarrassing for a start when they're 17. And I guess it's about that parent now having to realise that the relationship's going to be totally different with their young person, particularly if they want to maintain a relationship with them, because next year he's going to be 18.
Is it about child support? Is it about child?
Sometimes it is about child support. So I guess what you could say to them is when they're a younger person, it is about encouraging. And, you know, I guess there's nothing they can do to make the other parent encourage them.
Because, I just wanted to know about the encouragement, because...
When you've got a court order, you are supposed to encourage your children to comply with the order. So you'd say things like, oh, you know, mum and dad, we've got this agreement or we've got this order and you should go and talk about positive things about.
Okay, no, it doesn't.
But if they're 16, it's probably a little bit different then, because the court's probably not going to make an order against a 16-year-old kid. So they need to start thinking about, well, what might be a way you can sort of have a different idea about the relationship rather than, and that's about this thing about time. It's my right to time with my kid. I've got the order that says I get the time. Where it's really then becoming about how do you maintain a good relationship with your 17-year-old?
It's going to be very positive if they're
Parents, it's like those parents who say, my kid's not going to play soccer on Saturday because he's got to spend time with me. It's just so
Yes.
selfish.
And that's things that do come up a lot at mediation. It's my time, I'll do what I want in my time. I won't take him to his soccer match.
Yeah. It's all about
I want him to go, I've had one person say, I want him to go and do my car racing or something, because that's what I like to do, and he can do what I like to do in my time. And all that stuff. Okay, getting back to this, which is so often in the courts they'll have people where the presumption doesn't apply, and it'll be because often either there's issues of violence, issues of abuse, or they might say it's not in the best interests of the child sometimes the reason is very high conflict. In that case, the court doesn't have to consider equal time or substantial and significant time. But if they decide that substantial and significant time is what should be put in place, it's generally an order where it's not just every second weekend and holidays, but there's some time during the week as well. So providing people are living close enough, it could be stuff like an overnight during the week, or not just a weekend, a bit of time outside of the weekend that goes into school, and it depends on people's working arrangements, where they live, how far away they are, all that sort of stuff. Like, I guess the ideal, and probably also for if a parent is having most of the hard yakka work in terms of getting kids to school and getting them to do their homework, ideally it's helpful if the other parent has some of that hard yakka work and not just the fun stuff, if that's possible. And I guess the other thing you do see more, and not always from courts don't make a lot of orders for equal shared time, because they often don't have the type of people. But you do see a lot more court orders now for more time than, way back it was every second weekend, and then it was a little bit more, and now it's often a little bit more if it's practical. So any questions about that in terms of how the court makes these decisions?
There is no time in Family Law Acts before it was changed where, like, the courts favoured the mother due to attachment and things like that. Because we have so many, I have so many clients who are that are men, and they feel that the courts will always just favour the women. So I was just wondering if there was a history of that written into the legislation, or that was just
Favouring mothers.
or that was just due to in history with children and primary attachment.
I think originally, if you went back probably to the 90s, probably there were mostly orders being made for mothers. Part of the reason was, and it's still the case that most primary carers are mothers, so the research shows it's still the case that most primary carers are mothers, but also in society in the olden days, most carers were mothers. Most of the judges were old guys that had wives that stayed at home, and it was just also about what was going on in society at that time. So going back quite a long way, there had to really be something wrong with the mother to lose the child, sort of thing. Like she had a drug problem or something like that. At the moment, there is actually a court case that says there was never any motherhood principle. So the court sort of denied that there was any favouritism to mothers. And then I guess in 2006 all these changes came in trying to sort of push it towards shared time. But the research has got a lot of issues with that, particularly with people that are in high conflict. So what the research shows now is that still most primary carers are mothers, but there's a lot more now than years ago. Most single parents are mothers, but in terms of the court, I don't think you could really say that they favour mothers now. But that issue of attachment has become more important lately because there's been a lot of research on it. So when the 2006 amendments came in, the courts were really bending over backwards to try and give equal time because they thought, when they interpreted all of this stuff, they thought, well, Parliament has really wanted us to try and give equal time, so that's what we'll try and do. And then they started making orders that people got quite concerned about. Like, for example, there was a case where the parents had this history and they'd been into drugs, and the father had been in jail and he'd been a drug addict, and the court made an order for, I think, an 18-month-old to spend half time, 3 days on, 3 days off with the child. So the social science people thought, oh, okay, this is what this legislation's doing, and these people are in really high conflict, and every 3 days they have to change over this child. So all this research started happening about shared time and conflict, and particularly for young children. So the research shows that some of the very young children, like children under 3, there were issues with them having half time, particularly if they'd been a primary carer. You know, when parents are together, often there's a primary carer and sometimes there's not. If people were, say, they're shift workers and they're nurses and they're able to juggle things, they might actually be sharing care equally, and a young child's quite happy, quite used to it. But on the other hand, they might have decided, just for logistical reasons, that one person will stay home for a period and one person will keep working. So the research and the court cases have gone back to sort of considering that idea of attachment, particularly for children under 3. So if there has been a primary carer, that will be something that probably will be taken into account, but it's not actually in the Family Law Act.
Is that a yet?
I don't think they'll ever be in the Family Law Act because of a whole lot of political reasons. But on the other hand, if people haven't had a primary care arrangement, it might be appropriate for a child to, be moving. It really depends on the circumstances. But I think what some people have found, something that probably is missing too, is this idea of shared time being something the court has to consider. Really also doesn't take into account children's personalities and what they can cope with. So, although in the legislation it says it's got to be in their best interests and reasonably practical. Some children are quite flexible. And think of yourself as a child. Would you have wanted to move between houses and spent 1 week with mum and 1 week with dad? I personally wouldn't have, because I can't think of anything worse. And some people are okay with that, aren't they? Just think of your own personality. Would you want to spend 1 week in one house, 1 week in another house? Would you want to transport your stuff? And some of the research, they've interviewed some of the kids, and one child said it's like living out of a bag, and often they leave things behind, that sort of thing. So it's also about personality. It's also about age. The research has showed too that kids that start off in half-time sometimes move away from it as they get older. So as they get to high school, as they get to be teenagers, and they get it, and if their parents will listen to them, they might say, I don't want to do this anymore. Other children might keep doing it because they want things to be fair and they don't want mum or dad to be lonely, depending on who's got new partners and everything.
So when orders are made regarding children, is it to a certain age or does it?
Technically the order goes till you're 18, so once your 18th birthday it finishes. In practice, if parents are reasonable, they'll realise that as their kids get older, they have more of a say in what they're doing. And sometimes it's, you know, as they get older, like the 16-year-old, they don't want to go and spend
No.
and it depends where parents live and where their friends are located, where their activities are, all that sort of stuff. So if parents want those sort of arrangements, they have to also try and live fairly close to each other, make sure kids can still get to their stuff they want to do, make sure there's an Xbox or Nintendo something. I've had people where the kid doesn't want to go to mum or dad's place because they don't have the Xbox or the whatever. Now there'll be the Pokemon Go. Everyone can go Pokemon catching as long as they've got a phone. Okay, how am I going for time? Okay, so we might just do a little bit about reaching agreement and then we will go on to a little activity and then we can have our lunch.
Sorry, can I just ask a question on that as well?
Oh, I think you can.
Do you would and this is probably nothing to do with the law, but do you believe if you took child support out of the equation that everything would look a little bit differently? Do you get much of I'm pissed off because I have to pay for these kids I don't see?
I don't get a lot of that being actually expressed, but I get a lot of that being
Yeah,
underlined.
because I think that's the underlying thing. I think that's
Everything's about.
I don't get to see them, and that's what we hear day in, day out. And I always think if like you could say to them, "Well, take the child support out of this, and how much relationship you're with." I'm not saying it's good.
But isn't it intertwined? Like,
No.
so if you're seeing your
No.
children like
No.
once a
No.
week and
No.
you're
You've got to
paying
pay
all
a
the
certain- yeah.
money, wouldn't you feel like, well, I want to allocate where that money goes? To
No.
my
No.
Because she might have remarried her person and you still have to pay.
But also it's about, a lot of the issue is about, I've got to pay the money to her and she's going to waste it.
Yeah.
Spends it online. Yeah.
It's about the child.
Why?
It's also she's covering all the other costs out of her own money, so whether that money goes on to something else, she's still meeting those costs from somewhere else.
I mean, some
Yeah,
parents
it doesn't
make
matter where that
agreements that they
particular
pay the
$50
money
goes.
directly into school fees and membership, you know, like
Yeah, if they reach
dance
their own
and tennis,
agreements,
they can do that.
that's the way
Yeah.
to compromise,
Oh,
isn't it?
yeah,
They pay it straight in, so it doesn't go into her or his
Big
bank
enough
account,
line.
it goes into these, and that could be a really good way
And
of
something,
building trust.
Something that some clients don't pick up on too is that, say if you're in a parenting mediation, but say dad's not paying child support, but mum's really upset about that, and she's being really difficult about the time dad's spending, but he doesn't pick up on that's all underlying. So legally they're not linked, are they? You don't have to pay child support to get to see your kid.
Yeah.
No.
Yeah, and you can pay child support, but you don't get to see your kids sometimes, so they're legally not linked,
No.
but in a
Emotion.
mediation, they're very linked.
Yeah. Yeah.
And that's how you help them unlink.
Yeah.
Yeah, well, sometimes you can't uplink them for people.
Yeah.
Because if you perceive that dad can afford, because not often, but sometimes dads they're working, aren't they? But they are working, and mum knows that they can afford child support, but they don't want to pay. And until it's always going to be
Yeah,
difficult.
and sometimes people want half, 50-50 contact split because they only want to pay 50-50.
Yeah.
So they actually, sometimes they're not really wanting contact with their kids.
Yeah.
They
But
just
they're
don't
taking
want
that
to
week's
pay
probably higher than
her
child support
or him
to feed them.
as much money, which is really sad.
It does work on nights, doesn't it,
It
child
works on
support?
nights.
So people, even in, I've had mediations where someone wanted their kids for the night, but then they wanted to drop them back at 4 a.m. because they were a
I love
shift
it.
worker.
Alright.
Because they wanted that
Nice.
night.
Yeah.
Yeah, but if it doesn't, not a night, it doesn't count. It has to be a
Yes.
night. And so they'll want 2
So I
nights
think
a
you're very
week.
right about child support is sometimes, you don't often get people being very overt about, I don't want this because don't want to pay, or, but often it's underlying.
Lying, yeah. I think that, in my experience of Frau, they are very overt.
Oh, yeah.
Why
Like
do you have to pay
counselling
for things?
I think it's easier than
Well,
on the telephone.
Yeah, that's right, yeah.
Because
Yeah,
that
yes.
feels like,
They can't see your,
Yeah,
I
that's
think
it.
you're a bastard face.
Yeah.
You don't know who they are.
Will when you do a Skype.
Don't forget,
That's fine,
CSA got the direct line, so as soon as they get somebody difficult knocking up, straight through to us.
Yeah.
That's what happens.
And the moral of the story is don't go and get a job at CSA, do you think? 'Cause
Yeah.
it's such a volatile area, I think, child
Yeah.
support.
I've watched, just because I supervise, so I've watched sessions of mediation where the man was a CSA worker.
Oh.
And that just really, whew, was difficult. Because he just knew every little in and out. the whole
Because it is quite complicated too, child support. There
Yeah.
are ins
And
and
there's
outs.
so
and
many
technical
nights
things
and, yeah, like, there's a magic number, 38 or something?
52 nights.
52?
52 nights.
Yeah, 52 nights is the magic number.
Yeah.
She'll only want him to have the kids 2 nights a week, and he'll want 4 or something.
Yeah, yeah.
And you go, okay, what's this about?
Mm.
Oh, so it's one night a week? Right, or all the school
2.
holidays?
Yeah, 2 nights a week. What do you go? Yeah, 1 night a week.
One night a week.
Yeah.
And that's the sort of things, you know, when we get up to your intake,
Yeah, 2 nights a
when
week.
you're planning and assessing suitability, that's the sort of stuff you're looking for in your intake, is about, they might come to you because they can't see their children, or they want more time with their children, or whatever, but then there'll be other issues, underlying things. Other sorts of issues that can really impact who left whom, whether they were wronged, all that sort of stuff. Because people, that can sort of carry on. Things about fairness and trust, often about trust, which is a really hard thing to get around. Okay, well, we might now get you people to do a little activity. So you're probably sick of listening to me. Now, what we're going to do is, and we haven't started learning about the mediation process, but we're just going to do a little exercise. Where we're going to do and get an idea of experiencing. For some of you, you're going to be an arbitrator mediator. For some of you, you're going to be a client. So we've got a scenario about Kevin, the pot-bellied pig. Julia and Tim have separated. They were living in a de facto relationship for 10 years, so I'll just pass around the common facts at this point. And they have not been able to reach agreement on arrangements for their pot-bellied pig, Kevin.
Thank you.
So pass that around. So what we're going to do is we're going to get into groups of 3. Actually, I can't remember the total number. So we're going to get into groups of 3. One person's going to be the mediator arbitrator. One person's going to be Julia. And one person's going to be Tim. Then we're going to have a 15 minutes for an arbitration and 15 minutes then for a mediation. So once we've worked out who Julia and Tim are, you'll get confidential facts. Pink for Julia, blue for Tim.
I love it.
Aren't you?
Big cool. Molly used to call me Tip.
Yeah, well, that's true.
Now for the arbitration, so based on your confidential facts, for your arbitration, you're going to make submissions to your arbitrator, and your arbitrator will control the process. So Julia gets to make 5-minute submissions, Tim gets to make 5-minute submissions, then the arbitrator makes a decision, and they put their decision in this envelope. They don't tell Julia and Tim what the decision is. Then we're going to switch into a mediation. So because we haven't learnt the process, all you have to do for the mediation is again get Julia and Tim to make an opening statement, but you're going to try and get them to reach agreement. So 15 minutes for your arbitration. Arbitrator makes decision and puts it in the envelope. So you don't actually tell them what the decision is. Then you're going to see if you can reach agreement, and if you do get an agreement, you're then going to open your envelope and compare it. And then we'll come back to the group and have a therapy session, debrief about what happened and what it was like to be in the processes and how your agreements compared to your arbitrator's decisions. So do I have any volunteers? How many people have I got? 15?
Isn't that lovely?
Okay.
Is that right?
Yeah.
Oh, that's perfect. 5 groups. I need 5 volunteers to be my arbitrator mediator.
Yeah.